Judge, we have a plea on Mr. Diego Cuellar. He has his family support. May I bring them up with him? And his grandparents also here. These are the people that he lives with in Victoria, Judge.
Welcome back to the courtroom, where life-changing decisions, harsh consequences, and second chances collide in real time. Today's docket is absolutely packed with drama. We've got a young defendant choosing a conviction over a diversion program against the judge's advice, a repeat DWI offender facing a massive surcharge, a domestic violence case from 2021 finally reaching the courtroom, and defendants learning the hard way that plea deals come with permanent consequences. The judge is dropping serious truth bombs today, and some of these defendants are about to realize they just made decisions they'll regret for the rest of their lives. Let's dive in.
No PTA?
Judge, I've gone over this with him and his family many times. They understand thoroughly what is involved and the differences, the cons of this time served plea versus a potential PTI. The good thing is they have enrolled him in GED. He's getting back on track. He's back at home. It's just,
There's really, in reality, there's just no good thing that's happening today. It's not. You know, you can lead a horse to water, but you can't force him to drink. And I'm telling you that this is a terrible idea, but you're old enough to understand that actions have consequences. And the consequence is this day forth, this conviction will go on your record. It's going to be there for the rest of your life. People will judge you by how you look on paper. They don't care about anything else, because that puts the world on notice, who you are. And the more crap you put on paper, the worse your life becomes in every aspect, whether you want to get a job, whether you want to further school, whether you want to, you can't go to Canada anymore. You want to go to Canada? It's not going to happen after today. They won't let you in. The consequence, meaning the ramification of after today, will be so far reaching, you'll just never know. You have the option now to apply to get into a diversionary program where if you complete it successfully, they would dismiss this case. You would prefer to just plead guilty and just move on. And that's okay. But like I said, it'll go on your record. It'll be there for the rest of your life, even there after you die. And you ever get pulled over again, officers see this. They're going to roll up to your window. If they smell alcohol, they smell dope. It's probably not going to go well for you. And from now on, after today, if you continue with this, you'll be facing a minimum of 30 days in jail for any new cases that you pick up here for. You understand? Do you still want to do this? You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charged directly in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. That's what I said. So once you plead guilty, there's no turning around. It's not targeted. You can return it because you don't like it. One day, you will look back to the day in regret and say, why did I do that diversion program? But you can lead a horse to water, but you can't force him to drink. How do you plead to this offense? Guilty or not guilty?
Yes.
I'm going to find you guilty. I'll sentence you to the agreement. I'm going to suspend your license for 90 days.
Judge, will you consider a back suspension to DPS?
No.
Okay.
I'm not going to reward him for making this bonehead. No.
Judge, I can do that.
Nope. And let me give you a little bit more perspective, Mr. Cuellar. You're allowed to make mistakes, right? We all do. Everybody's human here. But when you continue to make mistakes where you endanger other people's lives, the penalties become a lot more severe. Like I told you, from now on, you pick up any more DWIs, it's a minimum of 30 days in jail. I am now going to waive for you the $3,000 surcharge that would otherwise apply to you. But if you come back here with another DWI, it is a $6,000 surcharge. And if you don't pay it, every $100 that you owe, you sit 1 day in jail. The only thing we ask is don't become another statistic. If you want to get ripped, if you want to get lit, 52 beers, 32 joints, take an Uber. Don't drive. Do you understand?
Sure.
How do you plead to the officer guilty or not guilty? I'm going to find you guilty. Follow the agreement. Good luck to you, sir.
We'll check some papers and get your court copy. You can wait.
This is one of those moments where the judge isn't just giving a warning. He's dropping a life lesson. Notice how he shifts from legal consequences to real-world impact. The defendant is being offered a diversion program, which means if he completes it successfully, the case gets dismissed. No conviction. Clean record. But instead, he's choosing to plead guilty and take time served just to get it over with. The judge is practically begging him to reconsider, explaining that this conviction will follow him forever. Job applications, travel restrictions, future arrests, everything get harder. And here's the kicker. The judge even waives a $3,000 surcharge as a last act of mercy, but warns that if he picks up another DWI, it jumps to $6,000, and failure to pay means jail time at $100 per day. Question for you watching. Do you think fear of a permanent record is enough to keep someone from repeating a mistake? Or do some people need to learn the hard way? Let me know in the comments, because this decision is about to haunt him.
Great job. We're really proud of you. You're doing great. We love success stories. And the only way that you have now is up. If you just write it out, do, what they're asking, the sky's the limit, The idea now is that you get a job and a good one, so you see their money start rolling in, because the idea is when you see that and you see how life can be, the only way to go is up. So the only problem that we need is that we need you to get a high school diploma, because that is going to prevent you, I think, getting many a job, because they said you have interest in truck driving, right?
Yeah, so
Yeah. So the first thing you need to do is to, at a minimum, try to get your high school diploma. We've got resource here so they can help you out to do everything that you need to get both of those things done. There's no fees, right?
So
we
he
can
just-
take care of everything?
he just updated me on something. He says he was only short 3 credits. So he's
So close.
he's actually going to go back to the charter school he was attending and take care of that so he can get his high school diploma.
You were really that close?
Yeah, I was that close.
I mean,
Slipped up.
okay, it's not a big deal, but I want to put a schedule on it so that we know what happens, though. We're not going to just leave it open-ended, right? So I would say within 2 weeks, to try to go get it re-enrolled.
Yes, sir.
So that we know what happens. People perform better when they have deadlines as opposed to just okay, go get it done. So let's say 2 weeks for you to get back enrolled, and then just let us know how fast it'll happen to where you can get those 3 credits done. And then we're going to have them help you get a, Class A driver's license so that you can drive trucks. You got to understand, though, is that when you're driving, that big of a truck, they drug test you like crazy. You cannot have anything in your system because they'll get rid of you in a second if you have anything, including weed, in your system. You understand? So it's just, there's no using.
This is what redemption looks like in action. The judge is celebrating a success story here. A probationer who's doing everything right. He's enrolled in GED classes, staying out of trouble, and now has a real shot at a career in truck driving. But notice how the judge doesn't just pat him on the back and send him on his way. He sets a deadline. 2 weeks to re-enroll in school and finish those last 3 credits. Why? Because people perform better with structure and accountability. The judge also drops a critical reality check. If you want to drive commercial trucks, you will be drug tested constantly, and even marijuana will disqualify you instantly. This isn't just legal advice. It's life coaching. The judge is using his authority to guide this young man towards stability, income, and a future. Viewers, Do you think courts should take this kind of hands-on approach with probationers, or should they just enforce the law and move on? Let us know what you think below.
Especially when you're operating 10,000-pound machines because I'm so proud of you. You're doing really well.
I'm proud of
Just keep it up. When you show up, good things happen. If you ever need anything, just come back, let us know, and I'll help you, and I'll help you get whatever you need. You want a job, you want this, that, I don't care. We'll help you with whatever you need. And then when you successfully complete this probation, I'll seal it for you. We will pay for it for you to get it sealed. Okay?
Yes, sir.
Because then the general public can't see it. It's great. All right? Great. Okay, good luck, Mr. Clark.
Thank you, Judge.
All right. Sir, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 1 year in jail to be probated for 18 months. Has he done the TRS yet?
Yes, ma'am.
No. You will do what's called a TRS. This is an evaluation to see what other conditions you may need. You must fulfill these conditions. If you don't, a motion to revoke will be filed. You will be put into custody, and we are going to have a hearing on whether to revoke your probation or not. It'll be DWI repeat offender education class, 2 victim impact panels, no drugs, no alcohol, no breath test refusal, meaning that if you're pulled over, an officer asks you to submit a breath test while you're on this probation, you must do it. A guardian interlock, 30 hours of community service, and 5 days in Harris County Jail as a condition. Is this how you understand it?
Yes, sir.
The more important thing to me, Mr. Garcia Ibarra, is you're young. What are you, 35, 37?
33.
33 years old. Your history sucks. It really freaking sucks. DWI dismissed in 22. DWI pled to in 23. Fleeing and eluding, interfering, and now open a DWI second and 2 felony assaults of a police officer. What's it going to take for you to get it, man? Is it a 25-year sentence? Do you know what happens next time you get a DWI?
Yes.
What happens?
It's a felony in jail.
2 and in the penitentiary. That's what happens next time. And with your record, as bad as it is, it doesn't have to be where you're stumbling, stupid, ball-ass drunk on the road. The mere smell, in and of itself, they're going to look you up. Every single time you get pulled over, they're going to harass and harangue you. It doesn't matter what you're doing, what time of day, where you're going. Every time you get pulled over with your record, they're going to harass you. So why give them the evidence? Why give them, of all the aches and pains, 1 button and $50 anywhere you want to go in this life? Do you understand? You're giving up the right to go to trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, like I said, it'll go on your record. It'll be there for the rest of your life. How do you plead to this offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty, and I'm going to sentence you to 1 year in jail. I'll probate that for 18 months. You will do a repeat offender DWI education class, 2 victim impact panels, guardian interlock, no drugs, alcohol, 30 hours community service. Do you have any children?
Sir.
If you do a parenting class, I will consider the community service waived. 5 days to begin April 28th. You must report by 6 p.m. If you fail to report, this deal is off the table and you're looking at an entire year in jail. Do you understand?
Yes, sir.
The other thing is this, Mr. Garcia Ibarra, I have to somehow get a hold of you so that you understand that we mean business. And there's 2 ways that we do that. One is by jail time. which now you're obviously not doing. The other is by hitting you where it really hurts. And that's what we're going to do. I'm now going to hit you with a surcharge that you will be required to pay. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. I don't know what else we have to try to get your attention, so that I'm hoping that this is it before you pick up a felony offense. It's a $6,000 surcharge, and then how much your court costs?
What was the driver's license before? A year ago?
1 year.
Okay, give me one second.
I will give you plenty of time to pay for it. We will give you a 2-year to 3-year payment plan. So that will give you enough time. If you have any problems, you can come talk to us. But the worst possible thing you can do in this life is pick up another DWI, pick up another case, or abscond, take off. Because if you do that, that's just, it's a guaranteed motion to revoke. You understand?
Sir.
How do you plead to the offense? Guilty or not guilty?
Guilty.
I will find you guilty. I'm going to sentence you to this agreement. For what it's worth, I usually waive these on almost every first DWI. You're now working your third. So at some point, like I said, we've got to get a hold of you to ensure that you don't pick up a felony or kill someone.
No, I just want to mention that I was talking to him about his finances, and my intention was to ask you to waive it, and I understand
I
you've made your
normally
ruling.
do, Ms. Casanova, on all first, but this is a third alcohol contact. You know, I'll waive his supervisory fees with regard to them, but I want to get his attention. And I think that probably the only way to do it is with money. And like I said, if you don't pay it, your butt's going to sit $100 for 1 day in jail. You're probably going to owe somewhere in the neighborhood of around $6,500 now.
Pause here, because this is a pivotal legal moment. When the judge says he's going to hit him where it hurts, he means financially. This defendant is 33 years old and already has a DWI dismissed in 2022, a DWI conviction in 2023, plus fleeing and eluding charges. And now he's facing a second DWI and 2 felony assaults on peace officers. The judge makes it brutally clear. 1 more DWI and it's a felony, punishable by 2 to 10 years in the penitentiary. But instead of sending him to jail now, the judge is imposing a $6,000 surcharge that must be paid over a payment plan. If he doesn't pay, he sits in jail at $100 per day. For repeat DWI offenders, money consequences are often the final tool before harsher sentencing. The judge is essentially saying, I'm giving you 1 more chance, but if you screw this up, you're going to prison. Think about it. Should courts rely more on financial penalties or jail time to change behavior? Drop your thoughts below, because this is a strategy that sparks serious debate.
Any slower, you'll be going backwards.
No. It's when people are watching. That's what happens.
Anyways, you get the gist of what it is.
Sure.
So I'm going to have you meet with everyone. If you have any questions, speak with probation. If you ever have any issues, come talk to us. Don't just take off.
Yes, sir.
Don't pick up a new case. And above all else, don't
6,400.
drink. 6,400.
6,400.
That's it. So I'm going to tack on this fee, but waive all the other fees. Yeah. All right. Good luck to you, sir.
Thank you.
Okay.
Approaching no bond conditions, Your Honor. He currently has a GPS monitor, a SCRAM device, and a curfew. And we were hoping to have the SCRAM device and the GPS monitor removed. He's been on it since February. He hasn't had any violations. And also with the curfew, kind of interferes with his work. Right now, he's limited to 8-hour shifts, but because he is the provider for himself, his girlfriend, and
What do you do for a living?
he works in the chemical plant. And from my understanding, the GPS monitor and the
Is he here?
He is.
Okay, can you bring him up?
Yes, sir. Mr. Norton?
Good morning, Mr. Norton. So, you're now standing charged with 2 counts of assault. You 4 months ago had 2 other counts of assault dismissed. I don't know if alcohol is a big factor to do with it. There are a lot of people when they drink, they become happy, the life of the party. They're so much fun to hang around with. And then there are people who become the devil incarnate when they drink. I don't know what effect anyone has. I don't know you, but I just don't want you to drink. I don't want you to use. And that's why, well, great. Because we're requiring you to be, right? I'm not taking off the SCRAM. I'm going to tell you that now because I just don't want you to drink and I'm not going to take your word for it at this point in time. I'm willing to work with you with the hours if you truly need to go to work and you can show us that you're working and not just going out in the middle of the night for the sake of going out. Because I just don't want you out in the middle of the night. But if you show me that he's got a work schedule that really you need to work at night, I'm happy to do it. If you want to work more, I don't want to prevent you from working. I want you to work because I think that, you being productive is really a benefit to everybody involved. What hours are you asking for?
So I clock in at 7 every morning, 7 a.m.
Okay.
And work up to 12 at night.
This is huge. The judge is being asked to remove a SCRAM device and GPS monitor, but he's refusing to take off the SCRAM because alcohol is clearly a factor in this defendant's assault charges. However, and this is important, the judge is willing to modify the curfew to accommodate his work schedule. Why? Because employment is a stabilizing force. The defendant works at a chemical plant and needs to pull 16-hour shifts, which conflicts with his current 9 p.m. curfew. The judge extends it to 12:45 a.m., giving him time to commute home. This is a perfect example of judicial discretion in action, balancing public safety with rehabilitation. The judge keeps the SCRAM to ensure sobriety, but loosens restrictions to allow the defendant to support himself and his family. Viewers, do you think this is fair, or should the judge have kept all restrictions in place given the assault charges? Weigh in below.
Okay.
Because that's a full 16-hour shift. And I work that quite often. They might flip me the nights, but I can 9. So as long as I can get from 7 to 12.
I'm happy to give it to you.
Thank you.
Okay. Remember, though, that you have a monitor so we know where you are. If you're out doing something you shouldn't be doing, we're going to get wind of it and it's not going to go well for you. So how long does it take you to get from work to home?
So it's about a 45-minute drive. It's in Mont Melville and I live in Newport.
Okay. So you want until what, 12:45 then, give or take?
Yes, sir.
Okay, we'll do that. I'll modify your schedule. Just remember, don't do anything you shouldn't be doing. The last thing you want to do is go back to jail because you've got a great job. You could be potentially losing it by just, all these cases are because of one thing. What's that one thing? No. Well, yes. But other than that one thing, what is it?
Yes, my decisions.
Self-control. When you exercise self-control, even in the most stressful times, good things happen. You've been doing well. I'm happy to modify your schedule. So now, modify the curfew till 12:45 in the morning. Yeah, after midnight, 12:45. Okay. And baby steps will go. If you're doing well, you keep doing well, you keep at it. We will loosen the chains, so to speak, on how well you're doing.
Did you want to leave the curfew for, so 12:45 a.m. until?
No. So he's working, you leave the house at 7 in the morning?
No, so I have to be at work at 7.
So you leave,
Give me 5:30 or. So a 9 p.m. to 5 a.m.
okay, so we want him to work for like 6:15 in the morning or 6 o'clock in the morning. He can go. He's got to be back at home at 1 in the morning. So from 1 in the morning until 6 in the morning. Okay. All right, man.
Thank you.
Make us proud. You got it, dude. You are Richard Renteria?
Yes.
Mr. Renteria, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. What you're going to do, probable cause, you have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. This case stems from 2021. Okay, guys, please.
Thank you. Your Honor, on October 10th, 2020,
Yeah.
or I'm sorry, November 10th, 2020, the defendant, so the law enforcement officer was told the defendant got mad and made the complaining witness, his daughter, kneel on the floor for 4 hours. Woman's co-defendant attempted to cut the complaining witness's hair and called her a slut and a bitch. The co-defendant grabbed a brown extension cord and hit the complaining witness while she was naked, causing pain. The defendant came home and punched the complaining witness in the face multiple times, causing pain and visible injuries.
And it's a misdemeanor.
Yes, Your Honor.
Stop. Don't. Have you spoken to the complaining witness lately?
We have not, Your Honor. We have not.
If you ever miss court again, Mr. Renteria, I'm going to make your bond so high that you'll have your beard falling off. Do you understand?
Yes, sir. Yes, sir.
When find that there's sufficient probable cause to go forward with your case, I am now ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you. If I find that you're using, it's not going to go well for you. I am also ordering and issuing a protective order that identifies SR as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes.
I am also ordering you not to have any contact with this person and not to be in possession of any weapons. You violate this court order, the state can and will file additional charges of violation of a protective order, and that is the capital murder of misdemeanors. Do you understand? I'm going to do everything in my power to protect my community at all costs. I don't care who you are. I don't care what you are. If I find that you're a danger, it's just not going to go well for you. Do you understand me?
This case is from 2021. 4 years old, and it involves horrific allegations of family violence against the defendant's own daughter. According to probable cause statement, the defendant allegedly forced his daughter to kneel on the floor for 4 hours, and a co-defendant beat her with an extension cord while she was naked. Then the defendant came home and punched her in the face multiple times, causing visible scars. The fact that this is only now reaching probable cause hearing raises serious questions about case backlogs and delayed justice. The judge immediately issues a protective order with strict no-contact provisions, no weapons, mandatory sobriety testing, and a 200-foot stay-away requirement. He also warns that violating protective order is the capital murder of misdemeanors, meaning it's one of the most serious misdemeanor offenses you can commit. Viewers, how do you feel about cases taking years to reach court? Does delayed justice undermine accountability? Or is it unavoidable in an overburdened system? Let us know below.
You have the ability to hire a lawyer. I need you to fill out an application for me. I'll see if you qualify. Don't just put zeros because I'm not going to believe it. I need to know everything about you, how much money you have in the bank, whether you have a car, whether you work, whether you have stocks, bonds, mutual funds, IRAs. I need to know everything about you, and I'll take a look to see whether you qualify. Deputy Miranda's going to give you an application. I'm going to have you sign a receipt with Victoria. We will have you take a seat in the jury box while we create your bond conditions. We will have you sign them with our JLO, and after that, I'll see whether you qualify for a lawyer. Please. Don't. Just don't. Now it's not.
Sir, Renteria, I was disappointed in this case today. So I know this is an older case, Your Honor, so whatever date works best with your calendar.
Doesn't matter to me. It's from 2021.
Yes, sir.
So do you have discovery complete on Renteria?
I believe so, Your Honor. We had everything at one time. We're gonna I'll have to get with our admin on that and make sure that we have all the videos and do.
Okay.
The only thing we're missing on that, Your Honor, I did want to reach out and complete a new recall for that one.
Yeah, good luck. Being that it's daughter, so hopefully shouldn't be too difficult, but, so let's do this. Let's do 2 weeks just to make sure you have everything.
Sir.
I'm going to waive his appearance for the next one. Once we come back, assuming you have everything, I'm going to give you 30 days at that point.
Yes.
And then after that, it'll be a clear trial. Okay? I've already told him what's going to happen if he takes off again. so that he knows, let's just be done with this once and for all, and then, yeah, okay.
Thank you, Your Honor.
Mr. Renteria, I've given you now, it's a lawyer. It is your responsibility to stay in touch with Alan. If he tells me that he can't get a hold of you, if you start ducking and dodging, it's just not going to go well for you. And the next time you take off, the bond is going to go into just, you understand?
Understood.
I'm not asking much, man. I just want you to show up. And don't be a danger to my county. Okay? All right, Alan.
Thank you, sir. Also, I have Mr. Chauvin. We're going to plead this as soon as the plea paperwork is ready. He's going to sign it, and then we'd like to approach the plea real quick.
So he just pled to a felony case upstairs, right?
Yes, Your Honor.
Yes. We did ask, Your Honor, if they would consider a dismissal down here.
One was before the felony, Your Honor, and one was.
I just, with as many as there, so they did what?
Time served on one theft, dismissed the other.
They reduced it from a third degree to a,
Oh, over upstairs?
Yeah.
Yes.
Good morning, Mr. Gaskin.
Good morning, sir.
Charged with 2 counts of theft. Looks like you have worked out an agreement where they're going to dismiss one of those thefts in exchange for your plea on the other one. Is this how you understand the agreement?
Yes, sir.
It is 24 days in jail with credit for the 8 days that you have already done.
Okay.
You need to understand that this charge will go on your record. It's going to be there for the rest of your life. You need to understand also that if you ever pick up another theft, no matter what it is, if it's a pack of gum, you will be facing a felony charge,
Sir.
a minimum of 2 years in prison, a maximum of 10 years in prison. And if you've been to prison before, they're just going to enhance you until the day is long for a pack of gum,
Yes, sir.
case of beer. You understand?
Yes, sir, I do.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. There's no changing this.
Yes, sir.
This is what you want to do.
Yes, sir. I agree to it.
How do you plead to the offense, sir?
I plead guilty.
I'm going to find you guilty. I'll follow the agreement. Good luck to you, sir.
Thank you, Your Honor.
Mr. Chauvin, you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. Looks like you also have another case as well, a criminal trespass. I'm assuming, Alan, that was going to be dismissed?
Yes, sir.
Is this how you understand the agreement? It is 12 days in jail with credit for the 4 days that you have done. So that means that you've satisfied the time. The only problem is this is going on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 90 days in jail. Do you understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up your right to appeal. Do you understand? This is what you want to do. How do you plead to the office of resisting arrest? Guilty or not guilty? I'll find you guilty. I'm going to send you to it. Good luck to you, sir. Thank you, Alan.
Thank you.
We'll have you see the clerk. Thank you.
And there you have it. Another intense day in a courtroom where real lives, real consequences, and real second chances collide. We saw a young defendant choose conviction over a diversion program despite the judge's warnings. A repeat DWI offender hit with a $6,000 surcharge to avoid jail. A defendant getting his curfew modified to keep his job. A horrific family violence case from 2021 finally moving forward. And defendants pleading guilty to theft and resisting arrest with permanent consequences. The judge made it crystal clear throughout. These convictions will follow you for life. Future employers, travel restrictions, enhanced sentencing. It all adds up. But we also saw moments of hope. Defendants getting help with education, employment support, and even offers to seal records after successful probation. The system gave multiple lifelines today. But will they take them? If you found today's courtroom breakdown as gripping as we did, make sure to smash that like button. Drop your thought and opinions in the comment below. And don't forget to subscribe for more real courtroom drama legal breakdowns, and life-changing decisions. We'll see you in the next one. Stay safe, stay smart, and stay out of trouble.